Hello, everyone, and welcome to our summer edition of the Community Board Leadership Training Series. This is a series that was launched in the beginning of our administration to help community board members, newly appointed or reappointed members, as well as members of the public, learn more about the interworkings of government and of the community board role, the community board appointment process, as well as land use and rezoning, landmarks. We also have trainings in parliamentary procedure, Robert's Rule of Order, resolution writing, landmarks training, as well as a whole host of other open data and technology trainings. Today, we're very happy to bring to you our Land Use and Zoning 101, which is the much anticipated training from our head and director of our land use division, Lisette Chaparro. So we're very happy to have you doing this training, Lisette. And just a little bit of a bio for those of you tuning in. And Lisette Chaparro is currently serves as Director of Land Use for the Manhattan Borough President's Office. In that role, she advises the Borough President on a wide range of planning issues and helps to support Manhattan's 12 community districts on matters related to land use, historic preservation, and construction. Prior to joining the Manhattan Borough President's Office, Lisette worked for not-for-profit affordable housing developers in Hell's Kitchen and in East Harlem. In these roles, she managed construction projects, initiatives, conducted outreach to stakeholders and groups on large-scale developments and proposals. Easy stuff. Easy stuff. First included the redevelopment plan for the Port Authority bus terminal and the 2018 zoning text amendment for the district. The set graduate from University in Urban Studies and received an MA in City and Regional Planning from Rutgers University. So, thank you so much for this training. For those of you who are tuning in, we'll be able to questions after the third sections of the presentation. You can bring your questions to the question and answer feature as well as the chat room. But we prefer the question and answer feature. And without further ado, we'll go right to Lisette Chaparro. Thank you.
Thanks, Aldrin. Welcome everyone, and thank you for coming to our Land Use 101 training. As Aldrin mentioned, my name is Lisette, and I'm the Director of Land Use for Manhattan Borough President Gale Brewer. So tonight we're just gonna do an overview of land use and zoning, in particular as it pertains to community boards. In case people are trickling in, I'll give an outline of what we'll be going over as part of the presentation. As Aldrin mentioned, we will take questions in the Q&A box at the end of the second and third portions of the presentation, as well as at the end. So if you have any questions, you can feel free to put them in the Q&A box throughout the presentation. Just know that I will check them at the end of parts 2 and 3. But first, I want to start with a little background on the origins of zoning, in particular here in New York City. So land use is essentially the recognition that we have different uses that we can have in our land, right? So if you look at the left here, you'll see a list of different uses that include residential, commercial, there are parks, institutions, industrial uses, as well as mixed uses, so residential and commercial uses all together in one site. Zoning is essentially the idea that you can divide land into different areas or zones, and you can make a determination as to which uses are permitted or prohibited within those zones. The basis for zoning at its core really comes from the recognition that people in cities need both light and air, and that certain uses need to be divided as well so as not to create any nuisances. So for example, you wouldn't, in an ideal scenario, want to have any residential uses next to heavy industrial uses, right? And then when we look at New York City in particular, the beginnings of zoning for New York City sort of sprout at around 1860 with the first building code that was really drafted as a way to address fire safety issues. So there were requirements that buildings have things like internal fireproofing and cast iron columns. And there were requirements that there'd be certain ratios for street width to height of the building in some areas. However, that building code didn't take into consideration the need for light and air or the impacts that a building would have in terms of casting shadows on its neighbors. And in 1915, New York City, Lower Manhattan, had the development of the Equitable Building. It was a 42-story massive building at the time that essentially cast huge shadows on its neighbors, and is actually somewhat coincidentally where the Department of City Planning is currently headquartered. The construction of the Equitable Building is what really leads to the 1916 zoning resolution in New York City. New York City was the first city in the country to enact a comprehensive zoning resolution. And the major tenets of that zoning resolution were to promote the health and safety of the public, to establish height and setbacks for buildings, and also to, as I mentioned earlier, sort of separate residential areas from non-residential uses. So for example, keeping the manufacturing areas separate and apart from the residential neighborhoods. In 1961, the zoning resolution had a big overhaul, and part of the changes to the zoning resolution included establishing use groups and also introducing bulk regulations. So essentially dictating the shapes that different buildings can take as a way of ensuring light and air in different parts of the city. It also incorporated some of the new ideas at the time about urban design. And one of the big changes between 1916 and 1961, of course, is the advent of the vehicle, right? So the 1961 resolution also addressed parking requirements. So let's talk a little bit about the mechanics of zoning itself. Zoning essentially regulates the kind of uses that are allowed on a site, as well as the density through what we call the floor area ratio, or FAR. And we'll talk a little bit more about that later on. The form or the shape of the building, the number of dwelling units, how much open space is required, how much parking, how much lot coverage a building has to have, and is the distance between a building and the lot lines. If we look at this list of regulations, however, they're really sort of outlining from the perspective of having a brand new building, right? And there are instances where there is either new zoning or a change to the zoning resolution, and there is an existing building, right? So when we have a scenario like that, it often does lead to what we call a legally non-conforming use or a non-complying building. These are, again, like I said, buildings and uses that predate the change in the zoning And so they're essentially grandfathered from the new zoning. And there's a provision in the zoning resolution in section 52 that pertains particularly to buildings that are in that situation. This here is an official New York City zoning map. So here we see part of Manhattan. The areas that are shaded darker are special districts, which we'll talk about in a little bit. You can see where the L is, that's the Lincoln Square Special District, the CL, the Clinton Special District, MID, the Midtown Special District. I guess throughout the whole map, as complicated as it may seem, if you were to zoom in, you would actually see the zoning districts themselves. So you can see there's an R8 on the west side, an M23 far west, just to the west of the Clinton Special District. So this is an official map. As you can see at the bottom right, it is map 8C. So if you were to actually go on the city's website and look at this map, you would not only be able to see the map showing the zoning as it exists today, but also be able to click through and see the official zoning map from previous iterations and previous years before changes were enacted. I want to dissect a couple of things here. The first thing is a zoning district. So here we have an example of a C47 district. The first letter, when you're looking at a zoning district, speaks to the use. So we have three different uses here. You have R for residential districts, C for commercial districts, and M for manufacturing districts. The number that succeeds that letter speaks to the intensity of that use. And then finally, the number at the end of it will speak to the parking requirements that pertain to that zoning district. And then we can see the different colors here. This is an overlay that we did showing the different districts outlined in a close-up of the official zoning map. This is the zoning text itself. I also want to take the time to sort of dissect this in particular. So at the very top, you will see a date. That pertains to either when this part of the zoning resolution was last revised or when it was created. Just below that, you'll see the section of the zoning resolution. So you can say section 33-122, or you can say that it is Article 3, Chapter 3, Section 122 of the zoning resolution. And I should note actually just above the area that's circled in bold, that will be essentially the title that describes what this part of the zoning text is outlining. And the districts that are listed below are the districts in which the zoning text that you're about to read will apply. Anything that is in hashtags in the zoning resolution is a term that is defined within the zoning resolution itself. The zoning resolution has a whole section dedicated just to definitions, and it's section 12-10. And also I want to go over just the wide range of use groups that we have in the New York City resolution. So we have 18 different use groups. They range from residential, community facilities, commercial and retail, regional shopping centers and amusement, waterfront recreation, general service and automotive uses, as well as manufacturing. The zoning resolution also specifically will tell you different specific uses and what use group they fall into. That's the middle column that you see here. And then all the way on the right, you'll see a listing of which zoning districts that use is allowed in. And also just to talk a little bit about density. So I had mentioned earlier FAR, or the floor area ratio. This basically tells you how big your building can be or how dense it can be. To understand how much square footage you can actually build on a site, you have to multiply the FAR by the size of the actual lot. And at the bottom here, we'll see 3 examples of a development on a lot that has the same FAR, but a different sort of laying out of the Lego pieces, if you will. The first one is a building with 1 FAR, right? So it has a 100% lot coverage. And if you multiply, let's say it's 100 by 100, right? If you multiply that by 1 and you build only 1 floor with 100% floor coverage, you end up with that very simple layout, right? The second one is a site where it's the same site, but with 50% lot coverage. So that essentially allows the owner to then layer a second floor onto that half of the lot. So you have still a 1 FAR building, but with a 50% lot coverage, you're allowed to have it be up to 2 stories. And then finally, all the way on the right, on the third image, you see 25% lot coverage yields a building that can be up to 4 stories tall. There are height factor districts and contextual districts in our city. For example, on the left, you'll see an R7 district. There is essentially no height limit. So you see a building here that is set back from the street, separated from the adjacent buildings, and discontinues that street wall that we see actually taking place on the image to the right. On the right, you see the building pretty much is lined up right next to those buildings. That's what we call the street wall, and has a height limit imposed on it. Both these buildings essentially have the same FAR, but they are, the FAR is distributed differently. In contextual districts, this is a tool to essentially ensure that the development is exactly that, contextual with its surroundings. And you'll know that you have a contextual district when there is a suffix letter in that zoning district. So for example, like I said, the one on the left is an R7 district. The one on the right is an R7A district. So let's go over some different zoning concepts and tools. The first I want to talk about is special districts. So here is an example of 2 special districts in Manhattan. The first is the West Chelsea / Highline Special District, and the one on the right, Hudson Yards Special District. So special districts are essentially, they're bits that are written into the zoning resolution. They're geographic areas that have specific rules for a neighborhood that has a special purpose, right? So in both of these cases, actually, the special districts were created in large part to manage the onset of forthcoming new development with the priorities and needs of the neighborhood. In other words, in both cases, I would say that it was about creating a balance between new development and preserving what was already there in the community. There are also special tools that can be written into special districts, and every community board in Manhattan has them. So you can certainly look through the zoning resolution to understand better both the intent behind the creation of your special districts as well as what zoning mechanisms have been written into those chapters of the zoning resolution. Second thing I want to talk about is commercial overlays. So these are C1 and C2 districts that are usually mapped in residential neighborhoods, and the purpose they serve is to satisfy the need for local retail. The FAR for commercial overlays are usually limited to 1 or 2, meaning that the commercial uses can only exist on the first or maybe the first and the second floor of a building. So here we see an example of a commercial overlay drawn all along First Avenue, Avenue A, and Avenue B in the East Village, and it's mapped all within an R72 district. Also want to talk a little bit about the transfer of development rights. So whenever there is a building that is not using all of its FAR, that the owner of that property can then sell their unused development rights to a neighboring property, which is what we see taking place and the image to the left, right? So there is a zoning lot merger between those two sites. And you see the outline over the building that's labeled Lot A is the unused development rights. And that is then illustrated on Lot B in the dark gray as additional floor area that was, theoretically purchased by the owner of that site and building. On the right, we see an example from a landmark that has unused development rights and transferring it over to a non-adjacent building. That there are specific provisions in the zoning resolution in section 74-79 that will outline the requirements for that to take place, specifically the transfer of development rights from landmarks to other sites. We also have incentive zoning in New York City. So this is the basic premise that we can allow a developer to build a bigger building in exchange for a public benefit. Some examples under which we may allow that include affordable housing or creation of open space or a contribution to a improvement fund or some kind of fund that's established either in the zoning and or in a special district in particular. I want to also go over some of the city agencies to talk about what their roles are within land use. First, the Department of Building, they're the agency that is tasked with enforcing the city's zoning resolution. They grant building permits and certificates of occupancy for buildings. And as part of that process, review applications from owners to make sure that they are compliant with the zoning. The Board of Standards and Appeals is tasked with essentially giving property owners exemption from the zoning resolution and evaluating whether or not an owner deserves that exemption in the first place. They provide variances on either bulk or use for a particular site. And there are also certain special permits which the BSA is tasked with granting. LPC, the Landmark Preservation Commission, designates individual landmarks as well as historic districts, and they enforce the landmarks law. We'll talk a little bit more about them later on as well. The City Planning Commission and Department of City Planning, they study the city and write or alter the zoning resolution. They consider certain authorizations, special permits, and also are often the lead agency on rezoning efforts. And lastly, the Department of Housing Preservation Development. They're the agency that enters into and enforces agreements regarding affordability in new developments. I want to go a little more in depth with the Department of City Planning, given that they're sort of the big agency that most often is dealing with land use issues. As I mentioned, they're responsible for sort of the physical and socioeconomic planning for the city, but they also, you should know, provide technical assistance to community boards as well as other city agencies. So each one of your community boards will have a urban planner who is assigned to cover your community board. So in addition to those urban planners, DCP also has demographers, urban designers, geographers, and folks who specialize on specific issues like transportation or waterfront development. As we'll talk about a little bit more later, DCP is responsible for certifying that applications are complete and also play a role in really hashing out the environmental analysis for a particular land use application. So before we jump into the third section of the presentation, I'm going to take a quick look at the Q&A section. So Barbara asked, what is spot zoning and what are the pros and cons? Spot zoning is generally the notion that you can have specific zoning rules. Most often you're referring to rezoning a specific site. It's something that in the city of New York, we avoid doing. And in fact, we'll talk about the process that the Department of City Planning partakes in as they're evaluating an application. And one of the many things they look at is whether or not the proposal itself constitutes spot zoning. And when it does, they will often try to work with the applicant to ensure that we are not looking at spot zoning. There are, I wouldn't be the right person to tell you the pros of spot zoning. I think I just sort of alluded to the fact that there are really mostly only cons. The main one being that, it will essentially, in its nature, is something that will serve, a particular interest, either of the property owner themselves or another interest group or individual. We also have a question from Lori. Are air rights and development rights the same thing? Yes. Air rights is a more colloquial term. Development rights is the more technical term. Both of them are used interchangeably. In fact, I may use air rights during this presentation as well, although I try not to. Robin asks, does a developer always have to go through BSA to apply for a zoning variance? Yes, there are certain applications that can either go through the BSA or they can go through the Department of City Planning. The main sort of test from what I've seen in applications is, again, it actually gets back to Barbara's question about spot zoning, right? So if you can think about it this way, the Department of City Planning generally takes a broader view on land use and policy issues. So to the extent that there needs to be a zoning change, then that's something that the Department of City Planning usually takes up as part of a broader effort. However, as we'll discuss later, if there is a site that has a particular set of circumstances, and just that one site needs a variance, as opposed to a zoning change, then it has to go through the Board of Standards and Appeals. And then it will go over sort of what the thresholds are for getting that variance from the BSA. Dave asks, what is the difference between the two city planning departments? We'll talk about the City Planning Commission and the Department of City Planning a little later on. And if your question is not answered, then you can certainly ask it again in the end, Dave. Joan is asking, if the maximum FAR has been reached, can the developer still use development rights on the building? So I think if I'm understanding the question, this would be an existing building that has maxed out its FAR, and the question is, can they then build more? The answer to that question will again depend on what the zoning is really. There is such a thing as maxing out FAR, but there's also such a thing as maxing out height, right? So remember we talked about contextual districts. Contextual districts will also have height limits. So let's say that a building has maxed out their FAR and they're next to a building that has not maxed out, and they purchase development rights from that site that is not maxed out. They can use those development rights as long as they're not hitting the height limit for the zoning district in which they're located. So it is possible. Taina asks, are there limits to how large a developer can build through incentive zoning, regardless of how great a public benefit they offer? Yes, most often it's written into the zoning resolution. I gave some examples of open space or affordable housing or a contribution to a fund. Usually when those are all, I should note, examples of you know, different parts of the zoning text that are written in different parts of the zoning resolution, which is a very, very, very lengthy document. But you would have to refer to that specific part of the zoning text. At that point, you would have an applicant going before the community board saying explicitly under which part of the zoning they are seeking to get you know, to provide the public benefit and get the additional floor area bonus. And then you would be able to understand, you know, either there's a percentage limit or there's some other limit that is imposed on them in terms of how much additional area they can get as a result of providing that public benefit. So those are all the questions I'm seeing right now. If folks,
there's another question by Courtney Matakis in the chat room, and the question is: a landmark building or themselves non-adjacent building? Are there limits to how far?
You're cutting out, so I'm going to.
The question is in the chat room. Can you see the chat room?
Yeah.
Okay.
I think, is it Courtney? Okay, Courtney. Courtney's asking if a landmark building gives its air rights to a non-adjacent building, are there limits to how far away that non-adjacent building can be? Usually, I believe it's 1 block, but there are special districts that that allow for much farther transfers. So I know, for example, that in the East Midtown special district, it is more than 1 block. But I'd like to confirm that, Aldrin, and I'm sure you will be sending a follow-up email to everyone who is on this webinar. So I will write up a response to your question, Courtney, and Aldrin, you'll be able to circulate it to everyone who's called in tonight.
Yes.
All right.
And
Thank-
also, I'm not sure if you can still hear me, but a good example of that is the theater sub-district, where theater owners, so the theaters are landmarked, they cannot build up, so they're able to sell, transfer their development rights to other properties for which to purchase in a specific district. So that's a good example of not being adjacent or county corner or on the same block, but being within a designated district.
Yeah. Okay. So I'll go a bit into the public review process now. If folks have any questions about earlier parts of the presentation, you feel free to drop them in, and I'll check again at the conclusion of this next section. Okay, so before we delve into the public review process itself, I want to just differentiate between as of right and discretionary development. New York City's zoning framework is an as of right framework, and the majority of buildings that get built in this city are as of right. That basically means that they comply with the zoning and the building code. And that's essentially, you know, a project that doesn't require any public review and doesn't require any decisions by any city agencies. And the developer simply submits their application for the building to the Department of Buildings, and then they go through an approval process with that agency. That is different from development that requires an agency approval or you know, a variance or some kind of special permit or authorization. Those are all what we would call discretionary actions. Again, just as of right zoning itself, the framework we have is that the zoning resolution is very specific as to what is and is not allowed. The rules in general will apply to everyone. And it's really, the ethos is that you're supposed to have consistent and rational application of the zoning resolution so that you don't end up with any sort of deal making. And it also allows the market to easily respond to any changes in demand. The environmental review process is something that's established by the State Environmental Quality Review Act, or CEQR. That basically says that each locality has to assess the environmental effects of any discretionary actions that they are taking. The way that the City of New York implements CEQR is through CEQR, the City Environmental Quality Review. And there's a whole technical guide that essentially outlines what has to be included as part of the environmental analysis for an application. The CEQR is about legally required disclosure. It also will define the scope. We'll talk a little bit more about scope later of what can be approved as part of that discretionary action. And it also allows for community input as well as mitigation for any effects that result in the discretionary that result from the discretionary action. A key component of the environmental analysis under CEQR is what we call the reasonable worst case scenario, or sometimes the reasonable worst case development scenario. This is an estimate of what would happen if the proposed action were to go through. And there are different metrics that have to be looked at in different categories, which are all outlined here. They include land use, zoning and public policy, socioeconomic conditions, open space, shadows, infrastructure, air quality, transportation, public health, neighborhood character, as well as construction impacts. Those are all, those and all the other ones that I didn't mention are ones that have to be considered as part of the environmental review. CEQR itself also has a number of specific terms. The review requires identifying both projected and potential developments. There are essentially, the analysis sort of sprouts from two basic concepts. The first is what we call a no action scenario. So that is the status quo. What would be the case if this project, if this action were not approved? And then again, the second one is the reasonable worst case scenario, right? So what would happen and what would be impacted if this action were to go through? From those two, you know, the difference between, I should say, those two, you call the increment, right? So the compounded effects of the proposed action is often the basis on what you are discussing as part of the environmental review process. This is a neat flowchart showing what the CEQR process looks like here in New York City. We start, or I should say the developer essentially will hire a environmental consultant to do an environmental assessment statement. That environmental assessment statement will either give a positive or a negative declaration. A negative declaration basically means that the proposed action has no significant impacts on the categories that we just outlined a couple of slides ago. I can't mute myself easily, but I think that's just a passing car with music. So if there is a negative declaration, the process will continue, and we'll jump back or flash forward to that part a bit later. But for now, I want to talk about what happens when there's a positive declaration, meaning that the environmental assessment statement found that there is a significant impact in one or more of the categories that we had listed earlier. If there's a positive declaration, a consultant has to draft a scope of what they are going to be studying. As part of that, there are scoping sessions during which the public can chime in and talk and discuss and also provide input on what should be included as part of that scope. That scope is then finalized, and there is a public hearing for it. And a draft environmental impact statement is then prepared by the consultant. That draft environmental impact statement then has a public hearing. And at that point, the comments are sort of gathered so that a final environmental impact statement can be prepared. And so now we're at the same part of the flow chart, and the rest of the process can continue. Put a pin in that for 1 second. I want to just talk about the Uniform Land Use Review Procedure in general, what we call ULURP, and that is essentially a way that the City of New York evaluates many discretionary land use actions. It is a way to keep planning and land use decisions from being sort of top-down planning. And there are a number of different actions that require ULURP. We'll list them in a minute. And most notably for you all, there's a formal role for the community boards to be involved in this process. There's a specific timeline and clear expectations, which we will go over as part of ULURP. Some of the actions that have to go through ULURP include zoning map changes, changes to the city map, selection for city facilities, the disposition or acquisition of real property by the City of New York, special permits as well, and changes to urban renewal plans. The City of New York has a number of urban renewal areas, each with their own corresponding urban renewal plans, and the changes to those are subject to ULURP. This here is the pre-certification process for a ULURP application. This is essentially a role that the Department of City Planning sort of partakes in with the developer or the applicants. There is a lot of back and forth in terms of determining what the reasonable worst case scenario is. That's often a big sticking point as part of this process. There's a lot of discussion about the environmental assessment overall. And there are a number of submissions that have to be made on behalf of the applicant to the Department of City Planning before the Department of City Planning can certify that an application is complete. Once that is done, we then move into the ULURP phase. So this is the public aspect of the whole process, right? So step one is the Department of City Planning determining, like I said, that the application is complete and ready to enter the ULURP process. At that point, the application is what we call certified or referred out. Those both mean the same thing. And the application is then sent to the community board, which has 60 days to evaluate the application. That includes holding a public hearing on the application and writing a recommendation or a resolution on the application. After those 60 days, the application then goes to the borough president's office. And the borough president can have a hearing on that application and also writes a recommendation on the application as well. And then from there, it goes to the City Planning Commission, which has 60 days to evaluate the application. They talk about the application in a review session. They also hold a public hearing and then have a vote to either approve, disapprove, or modify the application. And we'll talk about modifications a little bit later. Finally, the application then goes to the City Council, which has 50 days. Again, they hold a hearing and then they vote to approve, disapprove, or modify the application. This whole process takes about 5 to 7 months. The reason why there's a range is because sometimes the community board will write their recommendation within 45 days, which means that the borough president's clock starts right away. And sometimes, though not very often, but it's possible that, that the borough president then could issue the recommendation 20 days later, right? So that the clock, so to speak, can be sped up in that way. The day counts that you're seeing are sort of the maximum. You should also note that, you know, in a scenario where, for example, a community board doesn't write a recommendation or maybe writes it on the 63rd day, that does not delay the clock. The borough president's timeline will begin either 60 days after it's referred to the community boards, or when the community board issues their recommendation, whichever one comes sooner. But if there is no recommendation on day 60, it still moves forward. Just to delve in a little deeper into the two components of the community board's role in the ULURP process. Like I said, there's an obligation to hold a public meeting that includes proper notice for that hearing. So our office can certainly provide guidance and support in that regard, but also your respective community board offices can advise on that as well. So that's essentially making sure that all your neighbors and community groups and other stakeholders are aware of this hearing that is taking place. And then on the other side, at the other end of it, the community board issues a recommendation, right? And it's important that as part of that recommendation, that the CB really look at the proposed action as opposed to just the project, right? So if we're looking at a map change, you want to evaluate that as an action overall and not focus in on the glass building that may result or that is being proposed as part of that application. You want to look at the overall action when you are issuing your recommendations. Also keep in mind that for your recommendations, there has to be you have to back it up essentially with an understanding of what the policy implications are going to be, as well as the planning rationale for the application in the first place. You can consider both the positive and the negative impacts of the proposed actions. Oftentimes there are specific findings that are outlined in the zoning resolution, which you should address whether or not you deem that those findings have been met. And then lastly, as we saw in the ULURP flow chart, the community board is far from the last part of the process. Every stage of the process thereafter holds a hearing, with the exception sometimes of the borough president's office, and it depends on the kind of application. So there has to be continued engagement and follow through from the community boards participating in the hearings, continuing if there are things that you really want to see in a development or as part of the development, or if there are changes you really want to see being made to the proposal, there has to be some follow through from the community board. And even if the project goes through ULURP, folks on community boards who have served for many years will tell you that there even has to be follow through beyond the ULURP process as well. So in reviewing the proposals, again, you want to look at what is being proposed and not who is proposing it. So the identity of the applicant should not factor into the recommendation in any way. Keep in mind that things like operating hours are not subject to the zoning resolution. Making side deals with the applicant is also really not advisable. And in instances where a member of the community board has a conflict of interest in relation to the proposed action, they are required to recuse themselves and sort of avoid any appearance of having any influence on how the board votes on that matter. Things like bulk use, affordability, design, historic preservation concerns, open space, economic development, all those things are factors that you can take into a review of a proposal. So for example, you can say that you recommend denial of an application because of the impact it's going to have on the local infrastructure, such as school seats or seats on the subway. You can recommend denial because you think that the proposed action will result in a building that is out of context with its surroundings. You can also recommend approval because you believe that the creation of new housing in your neighborhood is something that is very much necessary, or jobs are very much needed. or because the proposal includes something like a supermarket, which your community very much needs. Those are all sort of valid reasons for why you would recommend one way or the other on an application. The Borough President's review, similarly, we look at the findings when they're outlined in the zoning resolution, as well as policy issues and planning issues. We look at the environmental impacts, and of course, we always take into consideration what the community concerns are regarding the proposal. Like I said, we may hold a public hearing. If there is an application that will affect more than one community board, that action has to be heard at our monthly borough board meeting and is subject to a borough board vote. As you saw in the ULURP flowchart, that recommendation then goes to the City Planning Commission. The City Planning Commission, and this is, I think, is it Daniel who asked the question? There's a Department of City Planning, and there is the City Planning Commission. So there's some overlap, but the City Planning Commission itself is just a 13-member body. 7 appointees are made by the mayor. Each borough president has 1 appointee, and then there is 1 appointee that's made by the public advocate. The City Planning Commission meets regularly. Most of the year, it's about twice a month, and they vote on land use issues that are subject to city regulation. The chair of the City Planning Commission is also always the director of the Department of City Planning. So that is there to sort of ensure consistency in both of those bodies, and it has been the case for many years. As I mentioned earlier, they have the ability to modify applications. Excuse me. The City Council has a land use committee. That land use committee has 3 subcommittees. Depending on what the application is for, the application will be reviewed by one of the 3 subcommittees, either landmarks, public siting, and maritime uses, planning, disposition, and concessions, and lastly, zoning and franchises. When an application moves to the City Council, the application has to be voted on by the land use subcommittee, the land use committee, and then finally the full City Council. Just so you know, the land use committee has a few other items on which it has purview besides ULURP. It also has general oversight of the City Planning Commission, the Department of City Planning, DO-IT, the Department of Information Technology and Telecommunications, as well as Landmarks Preservation Commission. And they also, as you can tell by the name of one of the subcommittees, review landmarks issues. Okay, so as I mentioned, the City Council is allowed to make modifications to an application as long as that application, as long as that modification is deemed to be within scope. That sort of has 2 prongs. The first is environmental scope, which means that if the City Council makes a modification, that modification has to result in an impact that has already been studied as part of CEQR. Or the impact has to be something that can be studied in what remains of the ULURP clock. Now, you probably remember that the council is essentially the last stop on the ULURP train. So there aren't very many changes that haven't been studied that can be studied at that point. But it is possible. And if it is possible to study it, then it is something that can be modified as part of the approval process. The second prong is the ULURP scope. That basically means that the modification can't be something that is very fundamentally different from what the application is proposing in the first place. So for example, if the application is about building affordable housing, the city council can't then go and say, we want to incorporate a change into the zoning resolution that has to do with manufacturing. That's just considered outside of the ULURP scope overall. The City Planning Commission, by the way, is the agency that is tasked with determining whether a modification is or is not within scope. There are also other applications and land use actions that do not go through the ULURP process, so I want to talk about those briefly. The first is non-ULURP actions. These include authorizations regarding the use and bulk of buildings, as well as zoning text changes or zoning text amendments. The acquisition of office space by the City of New York, as well as selection for a site for a school. The public review component for this is a little different from ULURP, and it does vary from action to action. In some cases, they involve an informal review and presentation to the community board. And the review periods change, but they're usually either 30, 45, or 60 days. Again, they depend on what the action is in particular. Zoning variances, so this is something that is granted by the Board of Standards and Appeals, which we talked about earlier. In order to grant that variance, the BSA has to determine 5 different things as they pertain to that variance itself. Number 1, that the variance is being granted as a result of uniqueness, so that the site is facing an unusual condition, either because of site condition or the shape of the lot or the programmatic needs of the owner or user of that facility. Second, that the variance is in keeping with the notion that an owner is entitled to a reasonable return. Third, that it is in keeping with the neighborhood character. Fourth, that the hardship under which the owner is seeking the variance was not actually created by the owner themselves. And lastly, that the variance granted is the minimum variance needed to provide the owner with a reasonable return. And lastly, landmarks and historic districts. So I hope most of you know, but in case you didn't, we're having a separate session on landmarks on Thursday evening at 6 p.m. But I also just want to touch on it as part of this presentation in particular. The LPC, the Landmarks Preservation Commission, is tasked with not only landmarking individual properties, but also historic districts themselves. They have to review any alterations that are made to a landmark or to a building that is situated within a historic district. And that has its own public component, which again, I'll delve into more as part of Thursday's training session. And the LPC itself has 11 commissioners. They are all appointed by the mayor. The commission has certain professional requirements. There have to be 3 architects, one person with a historic background, planning and architecture background, and a person with a real estate background as well. So that is the conclusion of the third part. Yeah, we have some questions in the Q&A box, so I'm just going to open that up. So Elizabeth is asking, is the no action scenario the same as of right development? Essentially, yes, because yeah, and I've never thought about it that way. But yes, no action would mean that there's no special permission being granted to that area or that site, and so therefore, what it assumes could be built would be an as of right development. So yes. Michelle is asking, how can you prevent the EAS from being biased since the developer is hiring someone to do it and is paying for it? So a very interesting question. This is part of, when I showed that outline of the pre-certification process, this is something that the Department of City Planning is really tasked with honing in on, right? And this is also why when it is found that a particular project will have impact on the neighborhood or the community, that there is a whole public component to just the environmental review itself. So to the first part, the Department of City Planning really goes back and forth and really tries to hold an applicant to task and make sure that the EAS is an unbiased and technical report. But also there is a public component to the environmental review process that allows the public to chime in and say, well, actually, you know, I live on this block and I can tell you that, you know, the school seats are X, Y, and Z. And so this is why I'm really concerned. And so that whole public component of that process sort of works to try to hold the consultant and the developer to task in that regard. Billy is asking, is it therefore not appropriate to consider whether the party seeking a zoning change is a good neighbor with longstanding community ties? For example, let's say a restaurant seeks spot zoning to permit outdoor cafe. Can we consider their reputation, whether they have historically been responsive to community concerns, etc.? So I just want to know, first of all, outdoor cafes are not subject to ULURP, and they're not considered sort of, you know, by our land use department. So I can't specifically speak to that example. But what I will say is that in scenarios where there is someone who has a track record of, you know, not being a good actor, that certainly can be, can and is noted as part of either a recommendation or a resolution that is drafted by a community board. And it can and should be a matter that is raised as part of the public hearings that happen, but it should not be the sole factor. Again, when there is an application, there are elements usually of the zoning resolution under which the application needs to be evaluated, and so those pieces need to be taken into consideration as well. Eugene asks, is the pre-certification process public or is it meant to be primarily between developer and DCP? How long does I'm sorry, the screen moved, I think, because we got an additional question. How long does the pre-certification process typically take? So it is not a public process. The only part that's public, again, there's a bit of overlap in terms of the environmental review. But by and large, it is a process that is done between the applicant and the Department of City Planning. The duration really ranges and really depends. It is a very iterative process. I've heard anecdotally that it can take months, but it also sometimes depends on the preparation and responsiveness of the applicant themselves. So I've seen some applications that have been at the pre-certification stage for a longer time. And sometimes that's also due to financial issues, or there's a shift in something that's going on with the applicant in particular, and they put the project on hold. There isn't a specific dedicated timeline for that pre-certification process. So they really do run the gamut. Elizabeth is asking, will we receive a copy of the presentation to keep? Yes, we can make it available. I'm sure Aldrin will make sure that whatever questions we're not able to answer tonight, we'll send you the response via email along with this presentation. Sharon asks, what is the role of the city's Civic Engagement Commission and the city's land use review process and/or community boards? So Sharon, I hope part of the presentation was able to address the role of the community board themselves in terms of the recommendations that they're tasked with writing. As far as the city's Civic Engagement Commission, I am not aware, since they've been since it's been created, of any direct role that they play in ULURP. But Aldrin, or if anyone else even in this webinar has had any contact or is aware of any contact that they've had as part of the process, please chime in. But I'm not aware of any formal role that they play. Robin is asking, does CEQR always take place during pre-certification, and is it always completed by the end of that window? Not always. So it always starts during pre-certification. The whole, if you remember the flow chart, the part where there's a negative declaration or a positive declaration, that is pre-certification. However, very often there's overlap, and in many cases, in fact, I can't think of any recently where this hasn't happened. The City Planning Commission's hearing also serves as a hearing on the draft environmental impact statement. So at that point, there is an intersection of those two processes, and there is overlap. And then the two processes sort of move on parallel tracks through the ULURP process. Dave asks, do landmark air rights transfer have to show a hardship? No, they do not. The section of the zoning resolution is 7479, and that will sort of outline a number of requirements. I should note, it's less about hardship and it's more about protecting the landmark in perpetuity. So oftentimes, as part of the proposal, the applicant is proposing to fund or make capital improvements to either stabilize or improve or freshen up the landmark building that is granting the development rights. Myra is asking, in the ULURP process, it's my understanding and experience that the community board's vote and borough president's vote are more advisory and hold less weight than CPC's vote and city council's vote. Is this process unfairly set up to take account of community members' votes? To take less account of community members' votes, especially considering how city council has used deference when voting in the past. What I would say is correct, Myra, that that the votes, the recommendations of the community board and the borough president are advisory. You know, the question is less of a technical one, so I will just very frankly say that this is my read, my observation, and my belief is that, you know, there is a lot of soft power that also goes into play here, right? Like I said, the community board writes its resolution, but that is not by any stretch their final involvement in the process. There are a number of hearings that happen after the community board writes their recommendation, and they can essentially really make their voices heard, both with our office, certainly, but also with the City Planning Commission and at the City Council. So it is a way to sort of bring the issues, to the extent that you may have issues with an application or concerns or requests, to the attention of the parties that then have perhaps a stronger say. I will also note the City Planning Commission, their vote, you know, one of the interesting things that they are able to do, it's the first part of the ULURP process where the party that is evaluating the application can make a modification. But I will say, I don't have the numbers, but in nearly every case, and certainly every case that I've tracked since I've been at the VP's office, the City Planning Commission has voted to allow an application to proceed. And in a few cases, they have made modifications, but that is not the rule, or by any means the norm, with applications that go before the City Planning Commission. And then finally, Rena asks, what percentage of the time does a project go through that CB doesn't recommend for the area? Yeah, I don't have an exact percentage. I'm sorry, I don't have a percentage, but sort of, I think this is a little bit related to the earlier question we had, which is that, you know, there's sometimes outright disapproval for a project, but in many cases, they're just recommendations for how an application can be improved. And so that's sort of where the soft power that both our office and community boards can have it as part of the public review process. I will say the vast majority of ULURPs, once they are certified, they do make it through to the end. I think in the last, since January, we've had, I would say, maybe about 10 ULURPs, maybe between 10 and 15, just to be safe. 2 of them that I'm aware of did not make it to the final stage. And in both of those cases, the owner decided to withdraw their application. I have a couple of more questions that just came in. How is reasonable return defined? I'm pretty sure we can find some general parameters on the website for the Board of Standards and Appeals, which I'm happy to share. I don't think, however, that we'll have an exact definition. It is something that the BSA sort of evaluates on a case-by-case basis, and there are things that applicants have to submit as part of that determination as well. So we will send that information to everyone who has called into tonight's webinar. Indiana is asking, if you sell air rights, is it ever possible to request permission down the line to further develop your property, even though you have already sold the air rights? Not if you don't have any more air rights. So it's possible that you sold your air rights and you're maxed out at that point, and that later there's an upzoning, and then you can build. But you can't recapture your air rights once you've sold them and they've been built. Billy asks, for a neighborhood that already has very tall buildings and high FAR, what tools are there to require that developers put affordable housing? Would a height cap or downzoning survive legal review? I think that is very much a question for our advanced session, which is going to take place next Monday evening at 6 p.m. We'll talk a bit about mandatory inclusionary housing, which was implemented in the city of New York in 2015. That is essentially a tool that allows developers to build, well, actually, I should say, there's voluntary and there's mandatory. The voluntary falls within the realm of zoning incentives that we talked about, and that allows a developer to build a larger building in exchange for including affordable housing. And then mandatory essentially says that there are a number of different things that trigger mandatory inclusionary housing, but in general, if there is a substantial increase in how much can be built on a site, and substantial is generally defined as a 33% increase or higher, then that site has to provide affordable housing. And mandatory inclusionary housing outlines different options for both a percentage of affordable units as well as the different income levels that those units have to be affordable for. But that will be covered more in depth on Monday evening. Myra asks if the Zoning and Franchises Subcommittee has a responsibility to notify the potentially impacted community of a developer's intent to rezone. How is the community informed? So if there is a rezoning proposal and it is done, whether it's done by a developer or whether it is an effort that is undertaken by the Department of City Planning or another city agency, the notification is essentially the beginning of that ULURP process. So like I said, we refer to it as the application either being certified or referred out. And there is a formal communication in the form of a package. So both the community board, and I do this because we get them at the Borough President's office as well, a physical package of the application. I will say just very often, especially if there's especially a big application such as a rezoning, the developer or the applicant will give a courtesy heads up to the community board before that formal package is delivered to the community board's office. So very often you're looking at some point during, or sometimes even, again, for big proposals that are being done by a private developer, prior to the pre-certification process or during the pre-certification process, there is a sort of informal briefing or information that is provided to the community board about that application. So there usually is plenty of notice to the community board, but at the latest, the community board hears about the proposal at the point that the application is certified. So in other words, 60 days before their recommendation is due. So those are all the questions for now. I've got one brief section just to get through. So if you have any questions, you can definitely drop them in, even if they're about earlier parts of the presentation.
Lisette, I have a question, and I'm not sure if you're able to speak on it or not, but under what scenario or circumstances would you imagine that a developer would have to chop floors off of his building or decrease the building? Like, what would have to have happened or not happened for it to get that far along?
You're talking about a scenario in which not like an old building that's grandfathered in, but like
no, correct, yeah, correct.
So for those who are really, really interested in this, you might want to do a search for 1059 3rd Avenue. There was a Times article that very much outlined the issues on that building itself. You know, there's only really, I should say, been one building in the city as far as any reporter has been able to find that actually had to chop off its floors. And it was a building, I believe, on the Upper East Side back in the 90s. And it was the calculation of how tall it could go was based on a misreading of the city's map, which we saw an example of earlier in this presentation. You know, the example at 1059 3rd Avenue, which is also on the Upper East Side, really speaks to a scenario in which, and our office had heavy involvement in this, you have a building that was approved for construction by the Department of Buildings. In our estimation, contrary to the zoning resolution, and the calculations that were submitted as part of the building application by the developer were we believe, contained mistakes. So there are a number of avenues that can take. The primary one is called a zoning challenge to the Department of Buildings, which our office you know, sort of assisted with alongside with a local neighborhood group called Friends of the Upper East Side. So it entails a sort of a submission saying, here's what we think is wrong with this development. In this particular case, you know, we were generally saying that the building was overbuilt and therefore it needed to be redesigned in a way that it was either shorter or had less square footage. That is still an ongoing case. Most recently, the Department of Buildings declined to acknowledge that there are any outstanding non-compliance issues with the zoning at that site with the proposed building. There are a number of avenues that can be taken from there, and at this point, I'll say that this is not specific to the 1059 3rd Avenue site, but theoretically, and we can talk about this more again on Monday, because these are very interesting and very, I think, increasingly important land use matters. But you know, from there on, if the community wanted to continue to contest the project, it would go to the Board of Standards and Appeals, this being the latter, the appeals part of their purview. And then even after that, either the developer or the community group can then take the matter to the courts. There is a concept, and I'll just say this before I get too into the weeds and geek out for too long, but there's a concept in general in planning that, or in land use in New York City in particular, that you have to exhaust all your administrative resources before you can take a matter to the courts. So in this case, the administrative resources would be the zoning challenge to the Department of Buildings, and you have to bear out that process. And the second one would be the Board of Standards and Appeals, and you have to let that process bear out as well before you can sue over a particular development. So that is a very long answer to your interesting question, Aldrin. And again, for those who are interested, Monday the 29th at 6 p.m. we'll have a separate session on more advanced land use topics. I think we got one more question in the Q&A box. Elizabeth is asking, where can we access the zoning map and zoning text for ourselves? That's a great segue for our final section here, tools and resources. Sorry, okay. Zoning resources. We have on the left side, the zoning resolution, and on the right side, the zoning handbook. The zoning resolution is super, super long. The zoning handbook is not. Many of your community boards will have a copy of the zoning handbook. If not, it is available at the city store and at the Department of City Planning. The zoning resolution is also online. Before this year, I believe, or maybe sometime late last year, when you access the zoning resolution online, it looked like what you're looking at on the left side, which is basically a PDF document that is stale, had no hyperlinks, and it was just a bunch of words and sections. However, very recently, the Department of City Planning overhauled their website essentially to include a much better and interactive zoning resolution interface. The link for that is at the bottom of this slide, zr.planning.nyc.gov. This is just an example of the chapter on inclusionary. And basically you can see anything in orange here is a hyperlink. The words that are bold and italicized are defined. You're able to see the zoning resolution in a much easier fashion than you were before. And it also includes a really neat search feature that you can just sort of put some keywords into to really see the myriad parts of the zoning resolution that will address the specific thing that you've entered into the search bar. The second thing I want to talk about is ZOLA. So this is the city's land use map. This is great if you're looking at an application, or even if you're just curious about a particular site. It allows you to sort of have a closer look and understand what the zoning is. It'll give you information about the building. It'll give you a street view of what's on that building, and also tell you what districts it is in terms of school districts, council district, as well as which community board it's in. So it's a really neat tool. It's pretty intuitive. For those folks who are interested, I would recommend you just go on the site and then sort of zoom in to have a better look at a specific site that you have any interest in. There's also ZAP, the zoning application portal. This is where ULURPs and non-ULURPs and special permits and authorizations with the Department of City Planning will be cataloged. You can see projects that are in the public review process currently, as well as projects that have been completed or that have been filed. So in other words, are going through the pre-certification process. You can sort of filter them by a number of things, either year or community board or borough, and look through. Once you click on the application itself, you'll see an update on where it is in terms of the ULURP timeline. You'll also see a brief description of the application. And if it is a project that has gone through the City Planning Commission, one of the gems that is available on the ZAP portal is the City Planning Commission's report. And that will include a sort of comprehensive detailing of the application and all the matters that have been considered up until the point that the City Planning Commission votes on that application. So that is the end of the slideshow. I'll leave just this window up here. And I think we got a couple of more questions. Elizabeth, oh, sorry, I answered that question. Myra is asking, in her neighborhood in the South Bronx, developers are aggressively buying up properties and letting them sit until the area is rezoned. It's led to some dangerously neglected zombie properties. Who can be contacted and what info is needed to make the developers responsible for maintaining those neglected properties? In many of those instances, we would be talking about violations that can be issued. The first agency that I would reach out to via 311 would be the Department of Buildings. So you can call 311 and just let them know what the issue is, whether it's a structural safety reason, whether there's an issue with site conditions around the sidewalk, whatever the case is, you can call 311, file a complaint with them, and that complaint then has to be taken up by the appropriate agency. In most cases, it will be the Department of Buildings that will follow up, and then they impose fines on the owner. In cases where the owner is not responsive and there is a serious safety issue, you can, the Department of Buildings does have a recourse for those scenarios, and either finding additional ways to try to compel the owner to make improvements and secure the site, or sometimes they go in there and do it themselves and then charge the owner or take the owner to court. So that would be my recommendation about buildings that are in that condition. And Robin is asking, can members of the public who are not community board members attend these sessions? I'm assuming that by sessions you mean the webinars that we have, the one on Thursday on landmarks and the one next Monday on advanced land use. Let me know. Great. Thank you, Robin. So Aldrin, is that a question you can answer?
Yes, these trainings are open to the public. They've been publicly advertised on Gale's newsletter. So we've opened them up to community board members and members of the public.
Thank you, Aldrin. So that's the end of the presentation. I don't see any more questions, but I will follow up. There were a few things that were brought up that I want to be able to give complete answers to. So we will be sending you further information on the question about landmark and transfer of development rights, as well as a better definition, if there is one, of what a reasonable return is for the BSA analysis. Again, my name is Lizette Chaparro. I'm the Director of Land Use. If you have any questions that you want to ask me offline in particular, my email, if I can manage to put it on the chat, I will share with folks. Or Aldrin, you can also send an email to all the attendees when we reach out, and feel free to ask me any questions that you have as well.
Thank you so much, Lisette. And I guess to the community board members attending, we can send them an email with your contact information, as well as the contact information of your team who's assigned to the specific community boards.
Yep.
And we can also reiterate who the community board liaisons are to the community boards, because we have so many new members on the community boards. It's important they know who in our office is assigned to assist them. So thank you so much. And so Lisette Chaparro, thank you so much for this Land Use 101. We've gotten very great feedback about your presentation and about all the information that you've provided. And we look forward to the landmarks on Thursday and advanced land use and zoning on next week on Monday, correct?
Correct.
Yes. So thank you so much. We would also like to thank Elka Moretti, who's part of the Community Affairs Division and supports the Deputy Borough Presidents as well. So Elka, I don't know if you want to give a nice cameo appearance, but whether you do or you don't, we want to thank you for your help in putting this together. And also I want to thank Rosie Mendez, who's the Director of Community Affairs, who I believe is also listening in and does great work providing technical assistance, training, and supports to the community boards. So without further ado, I want to thank you again, Lisette Chaparro, and I want to thank all the attendees for tonight. I think at one point we had about 75 people listening in, and we'll be sure to to share this on Facebook, YouTube channel for the MBPO, and also email each registrant a link so they can see this at their own leisure again. So thank you so much for attending tonight's Land Use and Zoning 101 workshop. Bye-bye now.
Thanks, everyone. Thanks, Aldrin. And